Supreme Court justices. Your proposal today obviously moves further toward the federal system in lieu of parts of the federal system, and also embraces the Court of Appeals. And so they were materially different, but they raised the same sorts of issues that I think you'll be grappling with today. I, of course, won't read either my old testimony or the new, but I wanted to make just a couple of points that the committee will think about as you decide what to do with this issue this year. First of all, this conversation has been underway for 8 years. In a sense, it's been underway since statehood. We've changed our method of selection. Before, we used to elect appellate court judges. In the end, it was the 50s, if memory serves me correctly. We went to the current system. In the 40s, I have to go back and look at the history. The Missouri system, the merit selection system, the nominating commission system, whatever you want to call it. And Kansas actually was not dramatically different from the national trends in either of those. If you go back and look at judicial selection among the states, in the 19th century, direct election was predominant, which is not what I'm here advocating today. I'm simply saying that we have all collectively moved over time in how we decide to choose. And today, there's a variety of systems among the states. Some elect, some have some version of the Missouri plan, the merit selection system, the nominating commission system, including Kansas. Some have something that looks much more like the federal system. My point in saying all of that is that the mainstream is wide. And I think it's appropriate to allow citizens of a state to decide where within that mainstream they want to place their state in terms of the method of selection. I would submit that the reason the mainstream is wide is that there is an inherent tension within the judicial branch of our system of government that was known to the founders. You'll certainly find it articulated in the debates of the Federalist Papers and in some of the founding documents. It was designed to be that way, and it is still that way today. And that is the tension between, on the one hand, the desire for judicial independence. We don't want a judiciary that is a political creature. We don't want a judiciary that is merely a third political branch of government. And on the other hand, the desire to have a judiciary that has what I've termed in this years-long discussion significant or substantial or sufficient democratic legitimacy. And by that, what I mean is, if you think of a continuum between extreme independence on the one hand and extreme legitimacy, that is to say that people feel like they have a role in the judiciary's outcome, in the individual case on the other hand, the right answer lies somewhere in between. You don't want a judiciary that's beholden to public whims, but you also don't want a judiciary that over time allows a feeling to develop among the public from which all of our authority is drawn in whatever branch of government we serve, that they're disconnected. And so that's why you get that mainstream in the middle. There is no perfect system. My suggestion for the last 8 years has been that, in my view, I think we have notched a degree to one side of that mainstream, maybe at the edge of it, in favor of independence and in favor of democratic legitimacy, that is perhaps a notch too far. But it doesn't really matter what I think. I'm one citizen with one vote here. You all have a greater voice in this than I do at this point. My view is 8 years of debate where I think the debate has broadened, not shrunk, certainly I think become more thoughtful and nuanced, demonstrates to me at least that this is a real constitutional issue for our state. It's not something that some small faction or some collection of interest groups on either side is passionate about, so they're trying to drive the debate. It's a real choice about how Kansans want our judicial branch to be structured and selected. And so after 8 years, I think it's time to let Kansans decide. And that's my only message to you today. I would really encourage you, whether it's in this measure or a version of this measure or some other measure, come together in this session, put the question on the ballot, and let Kansas voters decide, do they want to reaffirm the system we have, or do they want to choose a different path within that mainstream that alters the balance between independence and legitimacy? It is not my choice, certainly not as Attorney General, nor even as an individual citizen. interested in this subject because you're distressed about some particular decision of one of the appellate courts on some issue, don't let that be your motivator. This is not and should not be about any individual case. And if that's what you're thinking, go home, have a nice drink, have a nice supper, turn on some TV, and kind of chill. Because that should not be the motivator. Nor should anyone be accused of believing that's the motivator. It's a real constitutional debate about where Kansans want us to lie within this mainstream. 8 years of real discussion suggests, well, this that's it for questions, Mr. Chairman.
Thank you, Mr. General. Are there questions for the Attorney General? I won't let you get off that easy. We'll have one for you. I know in a past professional life, you spent time working in the United States Senate. And clearly, as all of us here know, in a past professional life, you were the majority leader of the Kansas Senate. I know there are some concerns about difficulties with the Senate confirmation process at the federal level, given some of the idiosyncrasies of the United States Senate. Would you have any comment, given your experience in those two bodies, and how the system might work more or less effectively in Kansas than it does in the U.S. Senate?
Sure, I laid out those thoughts in my written testimony, as well as, by the way, three, I think, Scrivener's issues you might want to look at in language and measure if you work with advancing. So I trust you with that. But look, in any system of selecting, actually any of us, to any public office, but this is true for members of the judiciary as well, any system will, at the end of the day, only be as good as the goodwill and
hearing before us today.
Thank you. Good luck. Deliver it well.